Before we start, let me introduce myself and my groupmates first. I'm Dimple Damesa, and my groupmates are Miss Maria Beverly Durante, Mr. Christian Erich Evaristo, Mr. Vince Ivan Eco, Mr. Joshua Richter Gonzalez, and lastly, Mr. Emmanuel Guerra. Now, let's talk about the characteristic of criminal law, duration and effect of penalties. First of all, what is law? A law is a body of nature of conduct of binding legal force and effect prescribed, recognized, and enforced by controlling authority. It's designed to maintain order and regulate behavior in society. Breaking a law can result in legal consequences, such as fine or imprisonment. How about criminal law? Is that division or branch of public to which define crime threats of their nature and provide for their punishment. It is a branch of law that deals with criminal offenses such as theft, assault, murder, and other illegal activities that cause harm to society. The aim of criminal law is to protect individuals and safeguard the public by deterring criminal acts and punishing offenders. Act No. 3815, the revised penal code, contained the Philippine criminal law, and likewise, it includes different special law and decrees, which are penal. It came into its full implementation on January 1, 1932. Act No. 3815, also known as the revised penal code, is a law in the Philippines that outlined the criminal offenses, their corresponding penalties, and the procedures for criminal proceedings. It covers a wide range of criminal acts from minor offenses to serious crimes like murder and treason. The revised penal code helped maintain law and order in the country by outlining the rule for punishing criminal behavior. Next, principal part of revised penal code. 1. Article 1 to 20. Principles affecting criminal liability. These principles include the non-existence of a crime without law, classification of felonies, circumstances affecting criminal liability, extraterritorial application of Philippines law, and criminal liability of person for each other's act. 2. Article 21 to 113. Provision on penalties, including criminal and civil liability. This outlined the various criminal and civil penalties for committing offenses such as death, reclusion perpetual, reclusion temporal, and imprisonment for specific periods. This article also specifies cases ranging from corporate offenses, public officers, infidelity, and offenses against religious sentiments, among others. 3. Article 114 to 367. Felonies defined under different titles such as crime against national security, crime against the fundamental law of the state, crime against property, crime against person, crime against chastity, and others. These articles specify the elements of each crime and the corresponding penalties under the Philippine law. Source of criminal law. Act 4275, public laws enacted by the Philippines Assembly from 1901 to 1905. Commonwealth Act 733, laws passed from 1935 to 1946, cited as Commonwealth Act No. 625. Batas Pambansa 844, law passed by the Batasang Pambansa from 1978 to 1985 and cited as Batas Bilang 232. Presidential Decree 2034, enacted of President from 1972 to 1986. When the Philippines was under martial law, this the Presidential Decree number 1081. Republic Acts, Congressional enacted from the Philippines Independence Declaration in 1946 until the declaration of martial law in 1975. These congressional and enacted were resumed in 1987 when the present Congress organized under the 1987 Constitution. There are now over 9,000 Republic Acts. Now let's talk about the two essential theories in criminal law. 1. The classical theory. Characteristic. A. The basis of criminal liability is human free will, and the rationale of the penalty is retribution. Individuals are held responsible for their action due to their inherent free will, and the justification for punishment is to restore balance and justice for the harm caused. B. The statement there is a negligible or little regard to human element implies that the situation is being treated in a way that overlooks or minimizes the importance of human factor, such as emotions, intentions, and individual circumstances. 2. The positive theory. Characteristic. A. That man is occasionally obedient to a strange and dark phenomenon which constrain him to do wrong, even though contrary to his violation. Humans, despite their inherent capacity for reason and free will, can occasionally be controlled by mysterious forces that drive them to behave in a way that contradict their moral compass and better judgment. 2. B. That crime is a social and natural phenomenon, and as such it cannot prevent and treated by the application of abstract principle of law, jurisprudence, nor by the imposition of punishment. Crime is a complex phenomenon rooted in both social and natural factors, making it difficult to fully address through abstract legal principles or standardized punishment. Instead, effective crime prevention and rehabilitation require a holistic approach that considers the underlying social conditions, individual circumstances, and psychological factors contributing to criminal behavior. Theories of the origin of criminal law. 1. That criminal law originated from the private wrong of tort. 2. That criminal law originated from the political processes of a unified society. 3. Criminal law originated from the development of customs, usage, and tradition. 4. That criminal law originated from a conflict of interest in different social groups. Duration and effect of penalties. Section 1. Duration of penalties. Article 27. Reclusion perpetua of the Revised Penal Code of the Philippines state that individuals sentenced to any of the perpetual penalties, such as reclusion perpetua, can be pardoned after serving the sentence for 30 years. However, if the chief executive deems the convict conduct or other serious circumstances as unworthy of pardon, the pardon may be denied. Under the Revised Penal Code of the Philippines, the penalty of reclusion temporal ranges from 12 years and 1 day to 20 years. This penalty is applicable to offenses that are considered serious but not as grave as those punishable by reclusion perpetua. Prisión mayor and temporary disqualification refer to the duration of prisión mayor penalties, and temporary exclusion shall be from 6 years and 1 day to 12 years, except when the case duration shall be that of the maximum sentence. The term prisión mayor and temporary disqualification refer to the imprisonment of disqualification from holding public office, respectively associated with the penalty prison mayor under the revised Penal Code of the Philippines. The duration of prison mayor is from 6 years and 1 day to 12 years, with the possibility of temporary disqualification. However, in certain cases, the duration of imprisonment may be extended and to match the maximum sentence for the specific crime. Prison, correctional suspension, and disterio. The duration of the penalties of prison, correctional suspension, and disterio shall be from 6 months and 1 day to 6 years, except on the suspension as soon accessory penalty, in which case its duration shall be of the maximum sentence. As mentioned, the duration of suspension changes when it's imposed as an accessory penalty. In this case, its duration matches the maximum sentence of the principal penalty, which is the main penalty for the crime committed. This means that the duration of suspension can vary depending on the specific case or crime. Kind of deterrence. 1. Specific deterrence. Individual deterrence often takes the form of an older principle called incapacitation. The idea is to make it impossible for individuals to commit another crime, at least while they're in prison. Specific deterrence, also known as individual deterrence, is the concept that the threat or experience of punishment for a crime deters the individual who has committed the crime from reoffending in the future. The effectiveness of specific deterrence is determined by the certainty, celerity, and severity of the punishment. 2. General deterrence. Societal deterrence is what most people mean when they speak of deterrence. The principle here is that others will want to avoid criminal behavior because of the example provided by the punishment. It is the concept that the threat or experience of punishment for a crime deters the general public from committing crimes. Principle in the philosophy of retribution. 1. Proportionality refers to the parallel implementation of the law. Proportionality is a principle that states that the punishment for a crime should be proportionate to the seriousness of the crime. This means that the punishment should not be too hard or too lenient, but should be a fair and just response to the offense. 2. Just desert is the right term if we consider the culpability of each offender and the rank seriousness of their offense. Punishment is with no idea of vengeance or retribution. Just desert is an ethical theory that states that individuals should be punished based on their action, not their intentions. This means that someone who commits a crime should be punished for the crime itself, not for the reason for committing the crime. 3. Equity. If we take consistency to the extreme and see to it all of offender who commits the same crime with the same degree of guilt get the same punishment. This means that the punishment should be proportionate to the severity of the crime and should be applied equally to all individuals who commit similar crimes. And lastly, reciprocity. If we look at the punishment as a natural part of the social order and feel satisfied that offenders behind bars, the principle of reciprocity in retributive justice suggests that Those who inflict harm on others deserve to receive harm in return, not out of vengeance or malice, but as a way of restoring balance and upholding the nation that individuals should be held responsible for their actions. That is all for our topic. Thank you for listening. Goodbye.